Okay, I know we have one more witness in opposition. Did he get a chance to testify? Go ahead, Mr.
Thank you, Mr. Chairman. My name is Steve Regis. I'm Senior Vice President of Corporate Services for Cal Portland Company. And I'm offering testimony today on behalf of the California Construction and Industrial Materials Association, known as CalCEMA. Cal Portland Company is based and headquartered in Southern California. We manufacture cement, aggregates, sand, ready-mix concrete. We distribute those materials throughout California. Our company has both union and non-union operations. We produce both concrete and asphalt. But we respectively oppose AB 219, and here are a few of our concerns. First of all, ready-mix is a local business. The ready-mix plants are local. They're dispersed in every community, and they deliver locally. We have stable workforces. We employ our workers throughout the year, including during the off-construction season, as opposed to being limited to the life of individual projects. It's very different from temporary or seasonal construction employment. The prevailing wage was not intended for suppliers. Concrete's a material, a supply delivered to the construction job site. Prevailing wage works well for construction where activities taking place in one location, but ready-mix concrete delivery is a fast-paced business where deliveries are made to multiple locations from multiple sites to both public and private job sites throughout a single day. Often we use multiple plants and multiple drivers from different sites as spokes in a wheel to send loads to more than one location. It's not the type of activity that's easily captured by prevailing wage. We do not believe there's a loophole. Court cases and administrative rulings have consistently ruled that the delivery of ready-mix concrete from commercial sources is not subject to prevailing wage. It only applies in the limited circumstances where the plant or workforce is dedicated to the construction job site. If there's a batch plant on site and those drivers are following the job site safety rules and the job site work rules, they're subject to the PLA that's in site on that, the PLA that's in force on that site. Drivers don't engage in construction work. We're proud of our drivers. We think they are highly skilled. But again, court cases and administrative rulings have looked closely at the role of drivers and construction workers, and drivers are not construction workers. Fifth, ready-mix drivers are well paid. The Department of Industrial Relations wage survey for the industry lists an average wage rate now of $30 an hour. We have union workforces that are compensated well above the state's prevailing rates in some locations. Sixth, this bill targets and singles out one individual product. By singling out concrete among all the different building supplies, it disadvantages concrete in the marketplace. There are costs associated with this bill. Never before has prevailing wage or these different contracting rules been applied to a single product. And then finally, but certainly not least, it adds a tremendous regulatory burden on one industry due to some of the unique provisions in this bill. Most significantly, it makes a fundamental change in the way we do commercial business by changing us from a supplier of material to a subcontractor. That's a huge change for us. It's a sea change for us. It means that ready-mix companies would have to obtain performance bonds for each job. We'd lose our collection rights that we have now, and we'd fall under subcontractor rights. We'd have to file claims for disputed work, and we would lose some rights. We'd have to meet new insurance requirements and new filing requirements. We'd have to individual companies would have to undertake a huge requirement for legal review of a large volume of subcontracts from various formats, various language formats. Every county, district, and school district and Caltrans have different contract formats, and the volume of those subcontracts will be much greater than for a normal contractor who's bidding a specific job. We're bidding myriad jobs. We're supplying myriad jobs across the state. Also, it places ready-mix companies under two sets of wage orders for labor laws, two sets of commercial codes for business transactions. The cumulative effect of all these changes in our status is exacerbated if you're a small business. You simply can't afford to have all the attorneys on staff to go through all that. In sum, the regulatory burden for just one material in one industry seems out of proportion to the minimal, if any, benefits of this legislation. We respectfully oppose the bill and would be happy to answer any questions.
Thank you again for your testimony. There's no opposition anymore. I think we're done there. Members, do we have any questions? We'll start with Vice Chair Stone.
Thank you, Mr. Chairman. First, for Assemblyman Daly, appreciate you being here today. It's been claimed that this bill is going to close loopholes, but federal and state laws have been consistent since the early 1940s. Prevailing wages do not apply to off-site manufacturers serving multiple customers. It does apply to on-site manufacturers, which was well articulated. There's been no confusion about this. So the first question is, why is a change in the law suddenly so important? And I'll get to number two now. The question of whether a mixer driver is involved in construction work has been reviewed by the federal and state government, and they have found that mixer drivers are not part of the construction work. They stay in their truck. They are not construction work. Then why do you want to promote this bill to apply prevailing wage to non-construction workers, especially when they're going to have to they're going to go from independent contractors to contractors. It's going to make them, from what I've heard from opponents, have to pay a $300 per year fee per driver, performance bonds, meeting onerous insurance requirements. And I'm going to further expand on it and say, why just, if you're doing this and you want to expand prevailing wage to the delivery of these commodities, as I would call it, a commodity, what about the lumber industry that delivers lumber? What about the pipe industry that delivers pipes? What about the food trucks that deliver food to these construction sites? Is this just going to be the beginning of applying prevailing wage jobs, wages to these other industries as well?
Thank you, Senator Stone. There's a fundamental concept at work here that I believe very strongly in, and that is when there's public money being spent on a public works project, the workers should receive a fair day's wage for a fair day's work. Many of the workers are receiving it, depending on the location of the batch plant and so forth, and past practices. But I think it's very reasonable to apply a prevailing wage to drivers who are doing the exact same work. The circumstances are slightly different, but I don't think it's. I think it's been custom, but that doesn't make it right. So I believe in the fundamental concept of prevailing wage.
Okay, what about those that deliver steel? For building a building, should they also be required to pay prevailing wage?
That's not the subject of my bill.
But I'm just curious, because public money is spending money on that at construction material. Why wouldn't you include steel or one that delivers lumber to a construction site? I think
it merits consideration, but it's not the subject of my bill. My bill, I kept it narrow because I think there's a gap. It may not be. I'm not a lawyer. It may not be a loophole in a legal sense, but there's certainly a gap in the way the drivers are paid for the identical work.
So, if that were the case, number one, why wouldn't the drivers of these cement trucks unionize and then go into collective bargaining? Maybe they have already, I don't know. But why aren't we hearing from hundreds of cement workers that drive these trucks here today saying, hey, listen, we don't get paid enough money. This is a great bill because this is going to put more food on my plate. Why are we not hearing from them today?
Do you want to?
I think, yeah. Well,
I mean,
it's a rhetorical question, I think, and I'll give you a rhetorical answer, which is that is the reason for the bill is for drivers who are not being paid the prevailing wage to get it. And some parts of the state have more union drivers than others. There are circumstances and stories behind every one of those situations. That's the reason for the bill, is to have a statewide approach to the drivers of this material that is an essential commodity for public works projects. The really large public works projects frequently have a batch plant on site.
I understand that.
But this is to address the gaps in the system.
Okay.
For drivers doing the same work.
Appreciate your answers. And now if I can ask a couple more questions to the opposition, to the Cal-SEMA rep. There's a contention that this bill will close a loophole and level the playing field. But as I understand, court and administrative decisions that have looked at this closely over the many years have consistently said that concrete produced from commercial sources should not be subject to prevailing wage, and concrete produced on-site should be, which you well articulated. Can you explain why there are these distinctions and why they should be treated differently? And even if this bill passed, would it level the playing field as it's claimed that they would?
As I said, if you're at a batch plant on the job site, you're subject to that job site rules. Your truck is on the job site. You're transporting concrete from one location on the job site to another location on the job site, and you're part of the job site and you're part of their work rules and their wage rates. On the other hand, if you're delivering concrete from a plant over here to the job site here, and then your next batch of concrete is going to come from a different batch plant in a different location to a different job site, that is not the way the prevailing wage has ever been interpreted. Concrete is a product, just like bottled water, paint. There's another provision in current law that if the contractor, the prime contractor, is using his own labor and his own trucks to go to a manufacturer's site and get concrete, then they are subject to the PLA. And that's similar, that follows the same concept as concrete is a product, as has been determined through case law. If you are a contractor and you get a delivery of bottled water, that truck driver is not paid PLA. The water company is not a subcontractor. On the other hand, if the site runs out of water and they send a truck to go get more water, that driver is in part of the PLA, assuming the job site had a PLA. Everything revolves around concrete is a deliverable product.
Thank you. And then one last question for Mr. Ackerman, if that's okay, Mr. Chairman, and I'll wrap up my question. Mr. Ackerman, can you just elaborate again on what are some of the practical impediments a prime contractor will face if the prevailing wage laws are expanded to expand hauling and delivery of ready-mix concrete?
The main issue, I think I'll expand on what my comments were during my testimony, is mainly dealing with enforcement. The general contractor is required to verify certified payrolls on the site. We are not usually the one that hires the delivery of the concrete. Usually it's a subcontractor that does that. So we don't even know which company is delivering a batch of concrete. It could be multiple companies that are doing it. We don't know when they're going to deliver. That's controlled by a subcontractor, but the responsibility trails always up to the general contractor on the job site. And we're very concerned of, again, expanding this to an entity that works on purchase orders, not contracts, on the job site. You have, as I think the witness from the ready mix from Portland Cement said, it opens them up to issues of liens, bonds, a whole variety of contractual issues that the contractor then is ultimately responsible for, and that's our major concern.
Thank you for your testimony.
Thank you. Any other questions from Senator Leno?
Thank you, Mr. Chair. Assemblyman, I will be supporting the bill today. I do get the distinction between the product we're talking about and delivering, in effect, dumping a delivery of pipes or paint or steel. This is a different commodity. But at the same time, I'm not insensitive to some of the points that have been made by the opposition. Excuse me. And I was just curious if you can share with us some of the amendments that were proposed or that you may have considered, if there's a way to soften what has been expressed as a blow, whether you get the opposition off of the bill or not, I think it can at times make it a better bill. I don't know what I'm talking about because you haven't shared them with us yet, but I'm just curious.
Senator Leno, I share your perspective. I certainly have respect for the industry we're talking about and the contractors, and we've done our best to comprehend and address their concerns. I'll let Mr. Diaz and Mr. Broad talk about the evolution of the amendments and whether and how they will apply.
So the First Amendment, one of the contractor groups came to us and said, we're concerned as general contractors that we won't get a certified payroll, and that, and therefore, could you add something into the bill that made these people a subcontractor for the limited purpose, essentially, of providing a certified payroll? We did that at their request to protect their liability. Now what they're saying is another group of contractors is saying, oh, you did that, but that somehow exposes us to liability for a host of other things. We're happy, once again, to take a further amendment, if necessary, if this is real, to clarify that we're not trying to implicate other forms of liability in the amendment we took for the employers at their request. That's one example. Another example is that they raised the question, if we're delivering in multiple jurisdictions, there'll be a different prevailing wage rate in every...
It's just the wage of the site.
Right, and now we made it the wage of the site, which means there's only a single wage. They never have to change that. That's different, but that was done at their request to make it simpler for them, and now the opposition is raising the question that that changes the current practice, and therefore it makes it more difficult for them. You kind of can't have it both ways. And when you're in that situation where you're amending a bill for people that will never remove their opposition, you're essentially negotiating with yourself, because no matter what you do, they continue to oppose the bill. They're just now opposing the bill on the basis of the very things we did to answer what we believed were fair and legitimate questions. And we will continue to do that as the bill makes its way hopefully to the governor's desk.
And if I may, Senator, and then some of the arguments are also just patently false. When it comes to actually having the complexity of signing up for the Department of Industrial Relations fee, it's $300 annually. The ready-mix industry, not per driver, it's annually for that particular company.
Okay.
This is a multi-billion-dollar industry. Certainly, the very small amount of these ready-mix manufacturers that are making a lot of money can actually afford $300 a year. That fee then pays for the Department of Industrial Relations enforcement of this type of work. So there's no general fund impact here at all. In fact, the resources that we're talking about at the Department of Industrial Relations, they're going to get those resources from the actual contractors on the annual basis. There was an issue brought up also about wage orders and which wage orders were actually going to be changed. That is not true. Again, this does not change any of the facilities and the wage orders they have to comply with. This is very specific, narrow definition of what prevailing wage is for this type of driver that is currently not covered. We've addressed a lot of the concerns. We'll continue to work with them on these issues. Again, if the issue comes up to clarify that the bonding, the liabilities, some of the other contractual requirements of public works contractors apply here, we'd be happy to work with the assembly member to devise something that says it's only for the purposes of the certified payroll record, which again protects the contractor who is liable for the penalties and the wages, like any other public works contractor that's out there, between a relationship between a general and a sub, right? Those laws were developed to ensure that the subcontractor would not just fold up, declare bankruptcy, and disappear, and leave the worker hanging with wages, and then no one would pay them. So the general contractor in this particular instance would all they have to ask for is, show me the certified payroll records. In an effort just to see whether they're actually checking the certified payroll records to absolve them from any type of penalty. They would be liable for the wages if the ready-mix facility were to fold up shop, which is not realistic in these examples here. But we're talking about the protection from the penalties. And so that's what this bill does, is it protects the general or whatever entity that's actually purchasing the concrete from the ready-mix supplier to be able to be protected from the penalties of the statutes.
The clarifications are helpful. Again, I would just suggest, I know the bill is going to appropriations, that not only for the sake of the bill and how it will operate in the real world, but also for your potential additional support on the floor, and every vote is helpful when you're putting a bill on the governor's desk, that even if the opposition is not about to remove their opposition, I suggest be open to any further amendments that might improve the bill.
I certainly am, Senator. Open.
And I move the bill.
Great, thank you. The bill has been moved. Any other questions? Seeing none, I appreciate the author bringing forward this bill. I think it's very important. It allows for a fair application of the labor code, since there are already instances where this work is paid by prevailing wage and provides uniformity in our law. So I appreciate that. With that, Madam Secretary, please call the roll.
The motion is to pass to appropriations. Mendoza?
Aye.
Mendoza, aye. Stone?
No.
Stone, no. Jackson? Aye. Jackson, aye. Leno?
Aye.
Leno, aye. Mitchell? Aye. Mitchell, aye.
Bill is out.
Thank you, Mr. Chair, and all members. Thank you very much.
Thank you. All right. Assemblymember Gonzalez, please step forward if you can. We'll start with item 4, AB 305.
Thank you, Chairman. Today, men and women are treated differently within workers' compensation. Gender bias isn't allowed in the workplace for hiring, and charging more for health insurance premiums based on gender is now against federal law. AB 305 eliminates gender bias against working women in California by applying the principle to workers' compensation. As you'll hear from our witness today, an employee with work-related breast cancer currently is told that the impairment of her breast is either 0% or 5%, depending on whether or not the worker is still of childbearing age. On the other hand, a man with work-related prostate cancer would be given a 16 to 20% disability rating. AB 305 updates our current law to state that in addition to the impairment rating guide used during medical examinations, the disability ratings for losing a breast due to work-related accident can no longer be less than the rating for prostate cancer. This legislation also identifies specific conditions found either predominantly or only among women. AB 305 disallows pregnancy, menopause, or osteoporosis causally related to menopause from being considered during apportionment when those conditions are contemporaneous with the work injury. Additionally, it prevents apportionment for psychiatric disability or impairment caused by sexual harassment. I've accepted a clarifying amendment from the committee to ensure that the apportionment provision of AB 305 would apply only to injuries occurring on or after January 1st, 2016. California has always been a leader on workforce equity issues. AB 305 is part of the overall fight for equity in the workplace, including equal pay for equal work, which is why it's part of the 2015 Stronger California legislative agenda. California's strength, size, and national significance makes this a critical place to ensure fair workplace policies for women. Being a woman should never be a pre-existing condition. I respectfully ask for an aye vote, and I have a couple of witnesses here to testify as well.
Great, thank you.
Good afternoon. My name is Janice Page. I'm a sergeant with the Sheriff's Office. I have been a peace officer for over 14 years. I love my job, and I'm proud to serve and protect the public. I have worked patrol, transportation, corrections, specialized units within my agency. As a first responder, my job also involved responding to vehicle accidents. Sometimes these vehicles were on fire. Sometimes there were gasoline spills. Other emergency responses involved gasoline fires, residential fires, commercial building fires, and there were always fumes. I remember responding to a prowler call one night. What we discovered was a natural gas leak. On February 2nd, 2012, I was told I had breast cancer. From the onset, I've had a total of 5 surgeries, developed an infection which hospitalized me for 6 days, and I had my right breast removed. The cancer was found to be work-related. I have returned to my job, but life is not the same. The loss of my breast has been devastating. Although I have an implant, it's mainly so I look normal. There is nothing normal about living without your breast. There is no feeling, and my body is missing an important organ. In addition to the physical changes, it has been very difficult emotionally. This has made me feel different about myself. When I started, I had 2 normal-looking breasts. Now I have 1 normal and 1 that is deformed. My right breast is higher and smaller than my left. It has been left scarred, distorted in shape, and a sensation of constant numbness. I'm embarrassed at my appearance and upset at having had a part of my body removed. I have filed a claim for workers' compensation insurance to provide medical care and compensation for my permanent disability. The law requires insurance companies to compensate me for my permanent disabilities resulting from my injuries. Although nothing can make up for the loss of a body part, there should be compensation for the resulting impact on my life. But I have been given a permanent impairment of 0% by a workers' compensation doctor who told me at the very beginning he had never handled a case as this one, and this was not his medical expertise. If a male officer had lost one of his organs, say his prostate, to cancer, the rating would be closer to 16%. Does that seem fair? I should not be discriminated against and have my disability compensation reduced because of bias against women. I carry the same weight on my duty belt as my male colleagues, confront the same dangers, work just as hard, and it's not fair for me and my fellow female peace officers to be penalized because of our gender. Thank you.
Thank you. Please.
Chairman Mendoza and Senators, my name is Crystal Schoenfelder, and I am here on behalf of the California Applicants Attorneys Association. I am proud to be a woman, and I am proud to advocate on behalf of California's women injured on the job. Because we happen to have breasts, this should never, ever be a reason to provide lower benefits to women who have suffered work injuries. Currently, the AMA guides, which is mandated for determining permanent disability benefits, states a female of childbearing age with absence of the breasts would have 0 to 5% impairment. An evaluating doctor would determine if a woman of childbearing age who had a mastectomy gets 0, 1, 2, 3, 4, or 5%. The AMA guides provides no disability, no compensation for a female who has undergone mastectomy after childbearing age. Yet for a male who undergoes prostate ablation for prostate cancer, the AMA guides provide 16 to 20% impairment for the ablation procedure, and this amount is then combined with impairment estimates for prostate and seminal vesicle loss, impairment for sexual dysfunction, and/or impairment for urinary incontinence. So a male firefighter who suffers prostate cancer from toxic exposure on the job and has prostate ablation gets at least 16 to 20% and higher if that ablation causes sexual dysfunction and/or incontinence. And a female firefighter or a female farm worker who suffers breast cancer from exposure to toxins or pesticides on the job gets at most 5% if she is of childbearing age and gets nothing if she is past childbearing age. It is completely unacceptable that such a disparity exists for women and men, and AB 305 is needed to rectify this situation. Reducing an injured woman's disability by 20% due to risk factors of age and gender is outright discriminatory. Taking away 50% of an injured woman's disability for her innate genetic predisposition because calcific deposits in the rotator cuff tendons are common in women penalizes an injured worker for being a woman. Indicating bilateral carpal tunnel syndrome is significantly influenced by an injured worker's pregnancy and breastfeeding when the symptoms began before the pregnancy and didn't resolve after the pregnancy is another example of unacceptable gender bias and discrimination. Reducing an injured woman's disability by 50% due to the fact that she is a postmenopausal woman is another example of penalizing an injured worker for being a woman. Being a woman cannot be a reason to reduce benefits. The conditions listed in AB 305 are completely unique or overwhelmingly unique to women, and it is unacceptable to treat women differently. AB 305 is not about words on a piece of paper. This is about real people, real injured workers, and whether we tell California's wives, mothers, and daughters if it's okay to receive less compensation than a man for their work injury. Please tell our state's women that they deserve to be treated equally and vote for AB 305. Thank you.
Thank you.